talk about making a will, and it's something that people think about a lot as they get older and as they approach death. They know that they need to put a will in place to deal with their affairs. What maybe isn't so much at the forefront of people's minds is making provision for their end-of-life care. Now, a will deals with what happens to your assets after you're dead. But there is another period of life where you may well need to make provision, and that is the time when you're still alive but you've lost capacity. You can't make your own judgments anymore. You can't make your own decisions. In those circumstances, you can no longer operate your bank accounts, you can no longer make choices about how you're cared for, about what sort of medication you receive. If you lose capacity, then all of those judgments become out of your control because you can no longer make them. You are, however, still alive, and possibly, almost certainly, at the most vulnerable point of your entire life. Now, if you've made no provision for that time, then you're in a difficult position. You may have significant assets. Most people own a house, you may have savings, you may have investments. Those funds could be used to pay for your care, to pay for the sort of care that you would like to have. But if you've got no capacity, then you're not able to sell your house, go to the bank, get the money out, and to get your assets available to pay for your care. So if you've done nothing to provide for that time, then your relatives or people who care for you will need to make a court application. It's called a deputyship application, to apply for the right to manage your affairs for you. And this is a time-consuming and costly process, and especially at the time when you want things happening instantaneously, is not an ideal situation. Far better is to put in place what we call a lasting power of attorney. Now, these are documents that you sign whilst you're still well, when you still have mental capacity, appointing the people that you trust, often it's family members, children, to be able to run your affairs for you when you can no longer run your own affairs. Now, these documents come in two forms. They're two separate documents. One is to do with property and financial affairs, and one is to do with health and welfare. The property and financial affairs one allows your attorneys to step into your shoes, effectively, for anything to do with your property and with your finances. So it allows your loved ones to be able to access your finances and to spend them on your care, not for themselves, but on your care for the time when you no longer have capacity. This means that if you lose capacity, your children will be able to arrange seamless provision for you, because they'll be able to access your funds straight away and to spend it on the kind of care that you need, maybe people coming in to look after you at home.